establishing our first business court. This had been a long-term goal of the section, and for years we had tried to convince the chief judge in Miami-Dade to establish a business court. We finally convinced the chief judge in Orlando to establish a business court. That was a huge accomplishment for the section. We had followed a number of other large commercial states, such as New York, in establishing a business court here. And after the chief judge in Orlando established a business court, several of our other large courts, including Tampa, Fort Lauderdale, and Miami, got on board and established business courts in those jurisdictions.
Started the UCREA task force, which passed this year. So finally we have the Uniform Commercial Real Estate Act, and so that's going to be great. And so that started in my year, and it just passed now. So sometimes things take 3 years. The other thing we did during my term was brought the Federal Securities Institute into the business law section. Had been a separate program, and so thanks to Greg Yadley, we brought that under the business law section roof. And so I think that's been an incredible program to add as part of the business law section membership benefits.
During my year, the American Bar Association had passed some revisions to the model rules of professional conduct that dealt with various issues, and the Florida Bar was considering whether to adopt those changes proposed by the ABA to the Florida rules of professional conduct. We were asked to look at it on behalf of the business law section, the proposals by the Florida Bar. Didn't have a problem with most of them, but we did have a problem with one relating to the ethical rules concerning prospective clients, and when dealing with a prospective client might create a conflict of interest that would preclude the lawyer from handling the case on behalf of an opponent if he was actually engaged by the other side after having been declined to be engaged by the prospective client. We wrote a letter that opposed the Florida Bar's position in that regard to the Florida Supreme Court during my year, and we supported the position of the ABA. Subsequently, though, the following year, when Maxine Long was chair, she graciously allowed me to make the argument before the Florida Supreme Court on behalf of the business law section. We were opposing the big bar, the Florida Bar, in that regard, and the Supreme Court actually agreed with our position, the business law section, and adopted the rule as proposed by the ABA. Bill Van Nortwick, I remember very fondly, was chair of the committee on ethics that dealt with that issue, and he and I met in his chambers at the first DCA to prepare for the oral argument, and I'll never forget that he was the one who came up with the hypothetical that Justice Anstead seized upon to, I think that won the case for us.
And one of my focuses was and has been certifications, because I had worked, when I was previously chair of the Business Litigation Committee, worked on getting a certification for business litigation, and I was part of the first group of people certified. So I don't know whether it was my term or around then. We also were working on getting an antitrust certification, and we're looking at other areas for certification and promoting certification.
We emphasized CLE rather than legislation. I think it was Scott Boehner the next year that cranked up the legislative program for the section. We had expanded the membership, and we expanded our CLE offerings. As I went back through the materials, I see that we had materials on corporate structure. We had continuing work in the bankruptcy area because the new law had come in 78, 79, and we had an expanding program using the judges from all of the bankruptcy courts throughout the state. And then, of course, we coordinated with the Florida Bar and some of the bar publications that dealt with secure transactions, various sorts of things. We also monitored the legislative efforts because we had a standard that there should not be secret liens, and there were always attempts to create some kind of possessory lien or some kind of lien that would protect unpaid veterinary bills, for example. And we wanted all liens to be a matter of public record so that banks looking at secure transactions could find out what the situation was.
I focused more on secured transactions as well as negotiable instruments and sales. That was all covered in the UCC. But beyond that, obviously we were fairly sophisticated practitioners. You young folks might not think so, but by today's standards, I think we were up to par, and we had some very bright people, and we did deal, and I'm sure there were banking law issues back then.
The IP law committee set up. But before that, we had some tremendous IP lawyers such as Michael Chesel and Steve Peretz and some other people, but they didn't have a committee set up. So we worked with Mike and Steve and some other IP lawyers to get a committee set up, and that's one of the best committees in the section now, so very proud of that.
The business court initiative was the nearest and dearest to me. Lots of work was done exploring how other states had approached the formulation of business courts. A lot of good work was done.
I think we were still working on central filing of judgment liens, and which was a huge thing that took 5 years to get done. Jeff Davis and I worked on that. He did all the work, but I did go to Tallahassee, and I was chair of the committee. He was the person the reporter for the committee, did all the work. And it took 5 years, but we finally got that passed, and that was a very substantial change the way lawyers perfect liens on personal property after they get judgments.